Hello, thank you for joining us. We are on HCCLA's Reasonable Doubt show, so we welcome you here. And we've got two very interesting guests. We've got Larry Williams.
Good evening, good evening, good evening.
And we also have Eric Davis.
All right, thank you for having me.
And I don't know how much y'all know about the Public Defender's Office, but both of these gentlemen work at the Public Defender's Office, and so do I. But there is a hierarchy. And so you've got the Felony Trial Division, and then we added recently a Misdemeanor Division. It's less than a year old, a little less than a year old. And then after that, we decided that we needed a Trial Bureau Chief for both of these divisions. So that Trial Bureau Chief is Eric Davis. So unlike me and Larry, he's got an extra title to his name. So welcome, we're glad to have you here.
Well, thank you, I'm happy to be here.
I won't even mention how many years I've managed to torture you as my mentor, but it's been fun. You've enjoyed it, right? Yes. Yes. This isn't coached at all. Eric, we're live. You're just supposed to say, yes, Jackie,
I will not lie.
Well, anyway.
It's been a journey. That's what he's saying. It's been a journey.
It has been a journey. To be honest, Jackie.
It's been a joy.
It has been a joy.
See?
See what you did there?
Mm-hmm. We can get there. So some of the things that we have going on in the courthouse right now pertaining to the Goins trial. Have y'all been keeping up with it?
Yeah, a little bit. Mm-hmm.
I went back and watched some of it.
I think I know what you're talking about. Yeah.
And so some information came out recently about body-worn cameras. And come to find out, the police chief basically said, yeah, I've told them to turn off body-worn cameras in certain situations. What do y'all think about that?
I mean, I think it's incredible, right? You would think that if anybody wanted to keep body-worn cameras running, were police officers. Because here you have the opportunity for officers to collect evidence in real time, right? And so body-worn cameras were initially designed as a check on the police because we didn't trust the police. We had issues that happened with the police, but it has a two-edged sword. I mean, if I'm in a case and my client has just allegedly committed a crime and the police show up and they do their investigation, you know, the credibility of the officer doesn't matter, right? They've got a body-worn camera to show what was done, to show how things were done, to show what evidence was collected, to show what my client said, to show everything. They've got a body-worn camera. The fact that officers would cut it off kind of speaks volumes about the integrity of the police and the integrity of what people believed about the police as well. You know, the police themselves question their integrity for them to cut body cameras off when they encounter suspects. You follow what I'm saying? It's like, so we can't see the evidence collection. We can't see what the police are saying. We can't see their interaction with our client when they cut the body-worn cameras off. It's like they don't even trust it for him to tell them to cut it off.
Yeah, and I think it's huge that the testimony that came out in this particular case was that it was, you know, former HPD chief himself, Art Acevedo, who literally told him, turn the camera off. Mm-hmm. You know, so it's literally the chief himself telling the other officer, turn your body camera off, and that testimony came out. So that's huge.
It's almost like he's saying, we don't want anybody to see our misconduct, so turn that off.
Yeah.
You know, which makes no sense.
I agree. Is there any circumstance in which you think it would be appropriate for body-worn camera to be turned off?
I think there's a few. You know, I've come across some body cams where they didn't turn it off, and you know, like I've had some officers go in the restroom stall. You know, what I'm saying, their body cams ran. At that point, okay, turn it off. Nothing's happening. You're not questioning anybody. Nothing to the case is going on, but you've just left your body camera on. So stuff like that, that's fine. You know, personal reasons. But when you're on the scene and you're talking to witnesses, or you're doing this, or even when you're calling the DA's office to file charges, like I think that came out a little bit in the trial too, as far as it's an office policy to where their intake won't talk to the officer if their body cam is still on. So I think that's a huge issue too. Like at that point, your camera should be on.
Yeah, I've seen that too in some instances. But I would agree with you. I think there's almost no reason for them to turn off body cameras. I think definitely them using the bathroom, maybe if he's calling his wife or if he's got some personal information that might get on the body cam, if he's going home, et cetera. I think those might be examples if the officer's trying to protect his personal information and if he's using the bathroom or something like that, that would be okay to turn it off. But if there's anything dealing with the scene investigation, anything dealing with interacting with witnesses, anything dealing with the alleged criminal investigation, the body camera should always come on. And if it goes off during and the officer turns it off during the call, I think that's a big issue with the case and should be an issue with the case. And as a prosecutor, I probably wouldn't want to fool with it, right? As defense lawyers, I think we've got to start making an issue of it. When I was a prosecutor, I had an approach that if it wasn't in the offense report, when the officer documented his report, then it didn't happen. So an officer coming back, 3 weeks or 3 months later, giving me all these details and telling me all these statements and things that were said that he didn't document in the report, in my mind as a prosecutor, I was like, hey, this didn't happen. You're going to get ate alive on cross-examination by the defense lawyer in this case because you didn't document these things that you're saying are important. And I think the body camera should be used the same way by us as defense lawyers in the defense of our clients' cases. If the body-worn camera is off or if the camera doesn't catch something or the officer's pointing in a different direction, any of those issues, all those things go to the officer's credibility.
Well, that tends to indicate that you were probably a reasonable prosecutor, Eric. But right now, we're dealing with a vast majority of people who are not reasonable prosecutors.
And we need to make them pay. As defense lawyers, we need to make them pay in their cases. If they take a case where there's some shenanigans or some issue going on with a body camera, we need to make them pay in the case. We need to use that. That's great ground for cross-examination.
It is, but by that point, our client has had to take the risk of going to trial.
I mean, we can present some of that to a grand jury in a grand jury packet. We can point some of those things out, as well. And if there is a controversy, if there's a different story or a different narrative of what happens that contradicts what the officer's saying that isn't backed up by a body camera, we can point out. So here he had an opportunity to verify or at least to corroborate what he's saying with the body camera, but he chose to cut it off at this point and present that to a grand jury in a grand jury packet. We can make the argument to prosecutors as well. I mean, that's not something that a prosecutor could fix, right? Because it's not in the body camera. It's not something they could fix. And if we think it's something we could fix, then we have to take it to a trial. And you're right. Sometimes, in some cases, our client can't get justice until we go to a trial. That's why we have trials.
But we are asking, in order for us to make them pay, we're also asking a client to go to trial and take the risk of trial. And it's going to be his word versus the officer's word.
I mean, it's always, the assumption that the client wants to go to trial. When I'm talking about us taking it to trial, it's always the assumption that we have a rightly informed client that we talk to, that we explain things to, and they made the choice to go to trial. It's not a situation where our client doesn't really want to go to trial, he's afraid, and then we'll say, we're going to make him pay and take him to trial. No, the assumption is that the client wants to go to trial. So granted, if we have a client that doesn't want to go to trial, then we don't go to trial. If we have a client we explain these things to, we explain to them the ammunition. It's in any case, right? We have some cases where we have good evidence of our client's innocence, and our client might want to take a time serve offer over our advice. That's going to happen all the time. But in cases where we have a client who's like, hey, look, what do you think, Mr. Davis? And we explain that to him and tell him the issue and explain to him how we're going to use it in a defense and then make them pay.
So, Larry, you were talking about Kim Ogg and her new policy that just started a few months ago, that the prosecutor's office wouldn't talk to the police unless they turned off their body-worn camera.
Right.
Why do you think she created that policy in the first place?
I mean, I don't want to assume, but I mean, it's obviously that there's some things that they have been hearing in the past or probably seeing on these body cams where officers are saying, I don't think this happened, or maybe we really don't have enough. And then it's like, hey, don't say that on body cam. We don't want that heard, right? We don't want people to know that that's the situation, that you really don't believe in this case. When you're calling the DA's office and you're asking for us to file these charges, meet your body camera, and then we'll have a conversation. And only then will we have a conversation.
Well, sometimes there are instances where the DA's office actually declines charges. Mm-hmm. And they tell the police officer why they're declining charges. And either it can be fixed or it can't. But
Right.
Then that becomes a record, and they have to either continue the investigation or, release the case altogether. Do you think that it has anything to do with Kim Ogg not wanting the office to be stuck with one lawyer's decision about whether or not probable cause exists?
I think that has a lot to do with it, and I think, in her whole tenure, she's had a lot of policies where even, in intake specifically, where, to decline charges even, the intake prosecutors, they have to do all this paperwork just to decline charges. So instead of doing the extra paperwork, they just take everything that comes in because they don't want to do this extra work to decline charges that they really know aren't enough to charges, right? So I think she's have a record of issuing these policies that result in different results for us and who we want. And I think, going back to what you said before about the body cams, I think one way that I've had some success is understanding that these officers have general orders and standard operating procedures. So there are things that they're supposed to do when they turn their cameras off, or when they say, my body camera died. There are protocols they're supposed to follow. Tell the sergeant, my body camera died, and then the sergeant says this, and then there's a protocol that's supposed to happen. And a lot of times it doesn't happen. They just put in for it, my body camera was dead, that's why there's no body camera, and no one looks into that to see what happened. Did the sergeant do what he was supposed to do, as your general order said when you said my body cam died? Because you can get some success with that too. Well, okay, cool, he said his body cam died, this is why it's not here, but he didn't report it to the sergeant didn't do this is what the general order say they're supposed to do. So I've had some success with prosecutors going that route,
Mr. Davis?
I mean, there's always an alternative, right? If a police, rarely is it that there's only one officer that makes the scene, right? Usually, if it's something small, you got 8, 9 police cars that are out in most places that are making scenes when there's an arrest that happens. It could be a misdemeanor case, right? Misdemeanor case with one witness, and you got 8, 9 police officers who make the scene and who are always on the scene. And so one officer coming in saying that he didn't activate his body camera. What about the 6, 7 other officers who were there? All their body cameras were dead? So it's a situation oftentimes where police officers don't want to activate their body cameras because they don't want it seen what they're doing. Right, and all of us have looked at body cameras, and we've seen some extreme stuff. And frequently, what we'll see on body cameras is accounts of events happening that weren't documented in police reports, and frequently that actually contradict what's documented in a police report. Right, and so I think if officers don't have body cameras, there's none of that accountability. Now, Kim Ogg's policy about cutting it off, some of it has to do with work product, what they believe is work product. Right, some of it has to do with issues of them counseling the officers about the case and pointing out issues that may potentially be with the case, and then the officer having some exchange. And some of it's political. Sometimes they want to create an environment where police officers feel free to tell them exactly what they want, and not to have that on a body camera. So an officer, they may ask them, so what do you think about this witness? You think this witness is credible? And the officer may say, I don't think this witness is credible. I think there's some serious issues of the credibility. The person who was in the intake probably wants to hear that, to hear about what the officer thinks about the credibility of witnesses so they can make a decision about whether or not they accept charges. Sometimes they may hear that, the officer saying, I don't think this witness is credible, and they may hear that there are other witnesses as well that can corroborate what the witness is saying, and so they may accept the charges even though an officer may think it's not credible. And so they don't want all of that on body camera. I think we should be entitled to hear that. We should be entitled to hear the officer's view about the credibility of witnesses, but there are reasons why they think that we shouldn't be, that it should be work product, because it goes into their thinking about the case and how their approach to the case is.
I think it's Brady.
It could be. It could be potentially. It could be potentially Brady. But I mean, in the officer's opinion itself, may not necessarily be Brady if he has an opinion that this witness is credible. Let's say you had a racist cop and he comes in contact with a black defendant and he thinks he's not credible. Right? Is that Brady because the officer thinks that the person isn't credible?
I mean, I think as a lawyer, as a defense lawyer, what we want is everything we can get. Mm-hmm. And then after that, we'll decide what to do with it based on our case. But I'd prefer to have it than not have it at all. So
with it being Brady, you can make the argument that the officer's opinion, even though he may be a racist cop, it is still an opinion that's favorable to the defendant and should be Brady. So I could see that. The officer could offer his testimony as an opinion, and he could offer his opinion. So I could definitely see that.
Mr. Davis, you had a lot of trials, right? I'm not calling you old.
You are, but it's...
I'm not. I'm calling you experienced. You're an experienced litigator.
Well, thank you, Jackie. I appreciate that.
Have you ever had a situation where after a jury has made it into the jury box, that somebody just raised their hand and said, I can't be fair.
After they made it in the jury box, I had some issues after the jury was sworn where I've had people say some stuff, you know. Did they just come out and say that they couldn't be fair? No, I've had some people tell me, for example, I had one trial where after a person made it in the jury box, they told me they told us that he was a retired police officer, you know. I had that happen once. Wow. Yes. So here we are. We're voir dire. Anybody, a police officer, anybody have experience with, no answers. But then they make it on a jury. Then they say that I'm a retired police officer. That distinction kind of wasn't made, even though we're asking about law enforcement and law enforcement experience. And so it was real fine, right? So I had that happen, and it was actually pretty good because that guy was a really good juror for us too, which was a positive. But I don't think I've ever really had anybody after voir dire. I've had people say they couldn't speak English. Had that happen once. Person saying they couldn't speak.
And we know how that happens.
Yes.
They didn't understand what was going on, so they remained quiet. And because they remained quiet, they end up on the jury.
Yep.
But it sounds like in the Goins trial, this juror actually answered all the questions, made it on the jury, heard opening statement, and thought, oh, I've heard these facts before.
And some other testimony. I happened to be watching when they brought her in to talk about it. So she said she heard, when she heard the 911 caller testify, that she started to recall a little bit. I think I've seen or heard about this in the news a little bit. And then she recalled it and she rode home with another juror. And, she was thinking about it. She said, oh, man, I know this case, I can't be fair. And then she called in the next morning and said, yeah, I seen this in the news, and just knowing what I know about it, I can't be fair. So, yeah.
So, I mean, I don't know.
So that's tricky, right? That's because that case, they had individual voir dire. Meaning they pulled that lady in and they talked to her individually, nobody else around, and they asked her a series of questions, and I'm sure they asked about pretrial publicity, and they told her about Mr. Goins, and they explained all of that to her. So
I think they spent 3 weeks picking a jury.
So what happens sometimes, and this might sound bad, but sometimes people get on a jury and realize that I don't really want to be on this jury, and will say what they can to get off. And that might be an example of that happening, right? That this juror realized I'm just not cut out for this. May have known that before they even got on it, and may have been struggling with the idea. And we get jurors like that all the time. You know how we have a juror who come in and says, maybe I could be fair, maybe I could not be fair, and they go back and forth, and we think the juror's helpful to us, so we want to keep them. So we'll do stuff to try to keep them. We'll talk to them, try to keep them on jury. Sometimes they're doing us a favor maybe by telling us that they can't be fair. Yeah. Maybe we ought to cut some of those people loose. And that could be the situation with that juror. So they may have been struggling with the idea of being fair, and the lawyers may have liked her because of the demographic. Do you know what her ethnicity is?
She was an African-American lady.
You see? So they may have kept her because she's a black lady, we got a black defendant, and they may have thought that she could have been helpful to the defense. And so they may have kept her on, and she may have been struggling with the idea and wanting to be fair. And they wanted to keep her on because they thought she potentially could be fair. And she looks like the defendant, and so people have that assumption that African-American jurors are going to be good. And, sometimes it's true, sometimes it isn't. Right? True. I know some black folk that have sent people to jail. That sent people to jail in a heartbeat.
That's why I laugh.
Yeah.
I don't know how black people sort of got pigeonholed as being so liberal when it comes to
jury service and the criminal legal system.
Yeah, right. And so I don't know where that came from, but it's not my experience that they're necessarily softer on crime.
Yeah, it's tricky, right? Because, if you have some African Americans have had crime happen if they live in a neighborhood where there may be some crime. But then again, a lot of African Americans have some relatives who may be in the criminal legal system or been handled by the criminal legal system. But most of the people have, he needed to be in it, right? They have that kind of feeling. He needed to be in the criminal legal system. He was filed. Right. Some will have that. So I think
even people who do have family members who have gone to prison are still like, yeah, I understand why he went to prison.
Yep.
And he deserved to go, and he did that thing, and he needs to pay for it.
Yep.
You know, so there's a whole another mindset that goes on.
As well, the overall writing part, because I'll be honest, the feeling you have is my client is a black man, and some people may have fear of him because he's a black man. That could happen. Some black people can be fearful of the black men, but you feel that it'll be less so with someone who is a person of color, that they won't have that fear. They won't have, my client doesn't have to worry about racism. He doesn't have to worry about somebody who fears him just because he's black. He has somebody that's going to be able to see his humanity if the person is black. And that may have been what the lawyers were thinking. They may have talked to her and thought that she's going to be able to see Mr. Goins' humanity because he's a black man. Yeah, he was a cop. And yeah, you know, he was a narcotics officer who put a whole bunch of black people to jail. I mean, he even sent George Floyd to prison. He had all those other issues too. Yeah, all those things are there, but yet a black person might be more likely to be able to see his humanity. And, you know, I think that people have a feeling that black people are fairer in terms of the system because they've been treated wrongly by the criminal legal system and they're more likely to question the criminal legal system. So there's some merit to people feeling that way. But I think overall we got to really find out who the people are. And
You remember us having a pastor who told us he couldn't be fair and we left him on the jury anyway?
I remember. I remember some mistakes of the past, and I remember good things happening in the past, too. I remember us trying a case and having all of the black jurors struck and seating an all-white jury. Remember that?
Wow. I remember.
And that jury acquitted him. Acquitted our black client. Yep, that all-white jury. Even though we were like, oh, wow, man, we got an all-white jury. And we fought it, made Batson challenges, the whole nine, and lost. And we won them one trial, and then we tried that same case again, and they did the same thing again. And we lost it the second time and tried it with an all-white jury, and that all-white jury acquitted.
Yeah. Yeah, I appreciated Judge Veronica Nelson for how she handled the jury, though, and then she brought each other juror in individually and asked if they had spoken to juror number 9, if she had said anything that made them biased or influenced them. So I appreciated the way she handled it. I thought it was still kind of weird because the juror number said she rode home with another juror that day before, but then she said, we didn't talk about it. I ain't say nothing about it. I realized it. I ain't say it. I got a text message, and I was like, oh, it's that case. I ain't say nothing about it. You know, do I really believe that? I don't know. I believe she probably said something, but I appreciated the way that Judge Nelson handled it and individually questioning each witness before they proceeded and giving the lawyers both sides opportunities to question those witnesses as well. So I appreciate her handling
What did they ultimately do?
They altered, what they ended up doing was they dismissed juror number 9, they brought in an alternate, and then they proceeded with the trial.
Mm-hmm. How many alternates did she see? Do you all know?
I'm not sure.
Yeah.
At least 2 I know for sure.
Mm-hmm. So that's probably the smart thing to do in the trial.
I think it was smart the way Judge Nelson handled that situation, but I think it was probably Nicole DeBoard who raised the issue of other potential jurors being tainted, other jurors potentially being tainted. And that's how they decided to try to see, like, first, let's talk to everybody. Let's see if anybody is tainted, and then we'll decide how to move forward after that. But, you know, as a defense attorney, I think it goes to show you always have to be ready to pivot. You always have to be ready to do something different. And I know we're always saying, hey, mistrial. I moved from mistrial. I moved from mistrial. I moved from mistrial. But in this instance, I think that that was a good,
wise move.
Yes.
Nicole is an excellent lawyer.
She is.
Mm-hmm. Very excellent lawyer, thinker as well. And so, you know, I would not be surprised that I don't think there's too many curveballs that could be thrown her way that she wouldn't be able to figure out and figure her way around. And Judge Nelson is seasoned as well. She's a judge that tried a lot of cases as a prosecutor and sat on a lot as a judge now too. So
the only thing we can really fault Nicole DeBoard for is her judgment in marrying Mark Hodgson.
I'm not touching that one. But yeah,
that's funny. Yeah,
great lawyers on her though. Like Reagan Wynn is down from Dallas and helping with that.
Reagan Wynn's on that trial?
He's on that trial. Yeah.
Oh wow.
He's sitting with Nicole Reagan Wynn. So definitely great lawyers on it.
So I don't know, Eric. What has been your favorite trial so far?
My favorite trial?
Yes.
You mean that we did?
No, just your favorite trial.
Oh, that I did? Oh, wow, that's a hard one. Oh, that's a hard one, Jackie. I still go back to one of my all-time favorite trials, or the trial I enjoyed the most, was the butter beans and cucumbers. Butter beans and cucumbers. That was probably one of my favorite trials that I did over the years. It was a case that I represented a 78-year-old pastor. I've told you about that before. Mm-hmm. That's probably one of my favorite trials. I did a trial where I represented a guy who spoke no English. Or at least he spoke very little English, broken English. And he did not want to use an interpreter. And that was a good trial. That was a fun trial too, because we struggled throughout the trial communicating. And we struggled throughout the representation communicating. But we did. We went to the scene. I went to the scene with him, him speaking very little English. I went to the scene and we walked through the scene and we communicated. It was work, but we communicated. And that was a very enjoyable trial as well. And so, you can always look back on your wins and see them as enjoyable. There's some losses that I had that I learned a lot from that were just incredible for me to learn. And I think I became a better lawyer from some of the trials that I lost. I'm grateful to say that I've won more trials than I've lost. But I lost a trial in Austin that I'll never forget, that taught me a whole lot. I learned so much from trying that case. 3-week trial, and we finished second. And the client got a 2-word verdict. I'm sorry, he got a 1-word verdict. And then we went to punishment. He did good in punishment, but that was a tough one. And I lost a couple of trials in Judge Rosenthal's court. One I lost, the client committed suicide after I lost his trial. He committed suicide. So that was really, really tough. But I learned so much from that experience. But if I had to think of a trial that was the most fun, it'd be the trial where I represented that 78-year-old pastor. Case I wasn't supposed to win. Case where we were arguing self-defense and didn't get a self-defense instruction. And it was one where I really had to reach down because I really cared for the pastor a lot. He had grown on me, and it was just so one lesson I learned, and I'm ranting a little bit, but I'll get back on track and focus. One lesson I learned from that case was to quote fees better. Right, because I remember when the So the pastor and his daughter came into my office.
So this is pre-PDO?
Yeah, pre-PDO. I was in private practice. He and his daughter came into my office and we were sitting down talking, and they told me about the case. And I said, I think I can help you. It didn't sound like self-defense to me. And then his daughter pulled out her purse because she was going to hire me. She pulls out her purse and it has a checkbook, takes out her checkbook. And she says, well, how much are you going to charge us, Mr. Davis? And so I tell her how much I'm going to charge her. I tell her my fee. And so she says, oh. So she takes her checkbook, puts it back in her purse, and then pulls out this wad of cash and starts peeling off my fee and pays me my fee. And I said, oh, I want that check. And as she's doing that, she tells me, so, it was between you and Rusty Hart. Oh. so I wanted, she said, me and my husband, we wanted to hire Rusty Hart, but my dad wanted to hire you. He said he got to have a black lawyer, right? And he did that. When she said that, he looked at me and said, yeah, your people fight. And so I was like, oh, I wanted to check. I could have added a 0 to it. And then I remember going to his daughter's house because his daughter, all of the stuff happened at his house. So his daughter made him move in with her. And I remember going to her house to meet with him, and it was this mansion in River Oaks. And as I was riding up, I was like, oh, I should have added a 0. So I learned so much about quoting fees in that case. But we ended up trying his case, and it was a pleasure. He became a good friend following the trial, and it was, like I said, it was a case we weren't supposed to win, and I had to really reach down to really fight that case.
Yeah, I don't know if you explained it, Eric, but we got Mr. Anthony Carpenter. He's butter beans and cucumbers. He's trying to know where that plays into this case.
Somebody asked that question.
Yeah.
I said that. Huh? So butter beans and cucumbers. So during the trial,
That's my brother.
Your brother asked that? Hey, what's up, bro? So man, when I was growing up, I told this story to the jury, and the story I told the jury because the issue was self-defense. We didn't get a self-defense instruction, so I had to shift. So I had to pivot, and I had to try to get jury nullification. And my client was older; he was 78 years old. And so I told a story about butter beans and cucumbers. When I was growing up, my dad would grow butter beans and cucumbers. There was a neighbor that we had. A neighbor was a man named Mr. Goodwin. Mr. Goodwin was older. He was like 78, 80 years old. Old guy. He was mean and ornery. If we kicked our ball and it went in his yard, he'd take it and keep our ball. We were playing football, baseball, it went in his yard, he'd keep it. You know, if he ever saw us in the yard, he'd threaten us and everything as kids, you know.
Like the Sandlot.
Like that. Well, we hated him. We hated Mr. Goodwin. We wasn't like, we hated him. We didn't like him at all. And so, you know, one day I was in our back room and I heard a dog bark and I look out the window and Mr. Goodwin was picking my dad's butter beans. He grew butter beans across the fence. And so he was picking the butter beans. So I run to my dad and said, Dad, Mr. Goodwin picking your butter beans. He picking your butter beans. And so my dad comes and he looks out the window and he says, And I say, that's all you gonna say? He getting your butter beans, that's all you gonna say? And he said, And so the next day, we went down into the garden because he had butter beans growing up against the fence next to Mr. Goodwin's house. And on this side of the fence, where Mr. Goodwin couldn't get to, he had cucumbers growing. So we went down in the gardens with a Swagman's bag, which is a big brown paper bag, and we filled it up with cucumbers. And my dad took the bag and pressed it up against my chest and said, here, take that to Mr. Goodwin and tell him if he needs any more, just come on and get it. Just come on and get them. And so I started my argument in that trial, butter beans and cucumbers. I said, and so after I said that, I said, there was a time when we used to care for our elderly neighbors. When we saw somebody who was struggling, we'd help them. And, you know, and so, have we strayed so far from the path? And that was my argument. We strayed so far from the path? And talked about how my client was a 78-year-old man who his neighbors were calling the police on him. His neighbors were harassing him. He was in this argument with him. And so I said, have we strayed so far from the path? There was a time when we cared for our elderly, when people who were infirm in our community, we loved them and we cared for them and we watched out for them. Have we strayed so far? We're at this point. And so that was the backdrop of the case. And so I argued that in the case. And that jury didn't deliberate. And basically they went out and rang the bell. And and then came back. And I said, oh, they checked testing the bell. And they said, no, they got a verdict. We're like, oh, wow. You know? they basically went out, ding, and they came back in and acquitted him.
Now, this is the same 78-year-old pastor who told you he just wanted the first 6 people on the jury, right?
Yes.
He wouldn't let you strike anyone.
He wouldn't. Well, he asked me, what we doing here? We were picking the jury. He said, what we doing here, Eric? And I said, oh, you know, we engaging in what we call jury selection. Of course, as we talked about all along, we've been talking about jury selection, so we're picking a jury. And we get a right to strike, you know, certain six of the jurors. So we listen to them and see what happens, you know. And so the pastor said, the Holy Spirit, Eric told me, he actually said, the Holy Spirit told me to strike the first 6 people. He wanted to strike the first 6 people. He said, Holy Spirit told me to strike the first 6 people. And I said, well, Pastor, Holy Spirit not saying that to me. You know, literally, I told him that. And so he says, Eric, the Holy Spirit has spoken, has told him to strike the first 6 people. And so I thought, there's no way in the world he could be serious, right? We got to at least see what the first 6 people look like. We don't know. They could be good for him. And sure enough, the first 6 people were solid self-defense jurors. Solid. They're the kind of people looking to shoot somebody, right? They were solid self-defense jurors. And I tell them, I said, see, Pastor, those people smiling at you. You know, they like you. You can't get rid of those people. And he said, Eric, the Holy Spirit has spoken. We got to strike the first 6 people. So we did. We struck the first 6 jurors in that case. Yes, we struck the first 6 jurors.
Do you find it difficult, and I know that you're a Christian, but do you find it difficult to sort of honor those Christian clients who want to do something that go against your legal expertise?
Do I find it difficult? No. I mean, do I sometimes counsel them the opposite? Yes, I'll counsel them different. But I try to listen to the client. Even the client wasn't a Christian, right? We represented Muslims clients. We represented Hindu clients. If a client has a view and a client's heart is bent a certain way, if that client is the rightly informed client, then we're going to honor the client. We're going to do what the client's suggesting. So I may have some clients who come in and are saying some crazy stuff, right? The evidence don't look like it's supporting them. I'll tell them, say, hey, look, the evidence don't support what you're saying. But at the end of the day, it is their life. Yeah. At the end of the day, I'm not complicit. I'm not complicit with the criminal legal system. You know what I mean? Too many lawyers are complicit with the criminal legal system. They view their role as, I'm supposed to facilitate things. I'm supposed to grease the wheels, to help a plea, to help convince him to enter a plea so he can go ahead and go down to the system so that the system moves smoothly. That ain't our job. Our job is to disrupt the system, if anything, right? Our job is to disrupt the system. Our job is to fight for our clients. And we do it in an honorable and integrable way. We don't lie to courts or anything like that, but at the same token, we're not supposed to grease the wheels to get our clients convicted. We're supposed to fight for our client if our client desires to fight. If our client wants to enter a plea, we want to facilitate the plea. But if our clients want to fight, we want to fight.
Well, now I want a shirt that says #disruptor.
Yeah,
That's
I
one
like
thing.
it.
Or not complicit, right?
Yeah.
Because, I mean, the criminal legal system is bent on convicting people and processing people. That's why we have mass incarceration. I mean, America is different than, now I'm going on a rant, but America is different than any other country, right? And that we have mass incarceration, that we view a criminal legal system that's penile in nature, that's bent on punishment, and that's bent on incarcerating people and not rehabilitating people. We have people who come in who don't have much criminal histories, and we'll label them in such a way that the person will always be someone that will be a ward of the state. We'll give them a felony conviction that limits their employment opportunities, limits their educational opportunities, limits where they can live even, right? Limits where they can live. And for many, it is a thing that is forever. And then we create probation, and people want to find out about probation. There've been some reforms, I'll acknowledge. There've been some reforms with pretrial interventions. There've been some reforms with things that can be done to help people limit their ability to be incarcerated. But it's still all being policed by prosecutors. Pretrial interventions are policed mostly by prosecutors. I mean, even probations and whether or not somebody gets a probation violation is policed largely by prosecutors. Yeah, there's some judges that can say prosecutors are going to do what I want, but the person that files the motion to adjudicate isn't the judge. The judge can direct them to.
That's the DA.
But it's the DA. Prosecutors police that. They police MHAs, they police MRPs, they police violations of pretrial intervention. They decide whether or not to file charges. They decide whether or not people should get it in the criminal legal system, should get it in the courts. And a lot of prosecutors are out of touch with reality. A lot of them don't have life experience. A lot of prosecutors don't care about people at all.
Isn't that what things like the MAC are supposed to be instituted to protect against, as far as judges, giving appointments to their friends or the people who they know are going to move the docket and being complicit? Isn't that what things like giving us the MAC, taking the appointments out of judges' hands and is that supposed to protect against that?
It is, but we don't have the MAC in felony cases, right? We don't have the MAC in felony cases, and we have judges that don't even honor. I mean, some judges do, but I wonder if we did create a MAC, would judges really honor the MAC? I think some courts, are excellent at appointing lawyers, right? And there's some other courts that will appoint lawyers that will move cases that aren't really as concerned about, the representation. And it really shouldn't be the judge's concern about the representation anyway. The judge shouldn't be deciding who a person's lawyer is. If the judge is going to have to sentence the person, the judge is going to have to hear arguments the person is going to make, the judge shouldn't be deciding who's representing them. It seems like, to me, an inherent conflict of interest for a judge to be deciding who's representing. I get the argument, because judges make an argument. We want to make sure they have good counsel. We want to make sure they have qualified counsel. We want to make sure they have counsel that knows what they're doing. And who better knows that than the judge? And I disagree that the judge is the person who knows that best. I don't think that at all. But I think that's the mindset that judges have, is that they want to control it because they want to make sure that people are represented properly, because they see people in their courts that aren't represented properly. And I agree that happens. There are people who come in their courts, and I've had judges tell me, say, hey, look, this person didn't know how to do this. This person didn't know how to do that. I think those are all legitimate concerns, but I think there needs to be an outside agency that polices that polices lawyers, that goes in and sets standards and will watch whether or not lawyers are meeting standards. In our office, we try to do that. In our office, we have senior lawyers like yourself, Jackie, who are supervising younger lawyers and who are teaching those lawyers and who's watching what those lawyers are doing. Now, I'm gonna be real with you. Some supervisors aren't all created equal, right? There's some supervisors like yourself that are like really, really on top of things, and some other supervisors that may not be on top of things as much as you are.
What was that, Eric?
I forgot that I'm being recorded. So.
I'm hearing like there's a raise in my future.
I plead the fifth. I plead the fifth.
Y'all all heard that? All at ACCLE.
I misspoke. Y'all recorded me. Redact the recording. Redact the recording.
It's live, Eric.
Yo,
She said it, not me. She brought up raises. I don't know. I'm not saying nothing. Go ahead.
So I asked Eric about his favorite trial. What's been your favorite case? Was it a trial case or something else?
Yeah, I mean, I think there's two that come to mind. So before the PDI, I was in private practice. I did a lot of work all over the state of Texas, a lot in East Texas. I think one of the best trials is a trial I did in Shelby County, Texas, in Center, Texas, a town called Center, Texas. Me and Sam Millers tried a case there, a drug case. We ended up getting not guilty there.
What made that your favorite?
I think like 16 minutes. Just man, just the preparation, man. We just went in, and I knew Sam, like he had gone to the same law school as me several years before, but we met while I was in school and stayed in touch. And, you know, just gave me an opportunity when I came out, like, hey, you want to try? He just sent a message, yeah, I'm good. Where are we going? And then we go, we're in a hotel, we working, and we just came up with this whole theme. We ended up having a banker on the jury, and so we had this theme of long division. You know, these officers in this case didn't show their work, so in this closing, you did a long division problem on the board, and you do it out. And in this case, you know, they didn't show their work. I mean, when we were taught how to do long division, you can't just get the answer if you know you got to show your work. They didn't do this in the case, and we did that, and I liked that case, man. So that was a good memory, and then. Also, I had a case here recently, I think in June or in the 248th, a felon in possession of a weapon case, and just helping the clients, man. It was just this client just really stuck with me because he was a client who had pled on everything. He had a history, but he had pled to everything he ever did before. And he said, Mr. Woods, I didn't do it. I'm not gonna take nothing on this from the beginning. It was a felon in possession. He said, look, I ain't know nothing about this gun in this car. I'm not gonna take nothing. Everything that I ever had in my history before I pled to it because I did it. This, I didn't do it. And he stuck with that. And then we were able to go to trial and get him on not guilty. So that stuck with me a lot because he had pled to, like I said, everything he had ever did. He took it. He said, yeah, I did that. But in this one, he was like, hey, I didn't know nothing about this. I ain't do it. It wasn't me. And he stuck with it, and we were able to get him the proper result. So that meant a lot to me.
Do you find it?
I was just gonna say that was one of my old clients as
Yep.
well. That he represented at trial. That I was one of the lawyers. I pled him to a case previously, and Larry went to trial with him, and that was real good, man. I appreciate that.
Yeah.
Do you find it more difficult to represent someone who does have that long history and then suddenly decides, this is the case I want to go to trial?
I think it probably presents more challenges for you. To me, I don't find it more difficult because to me, I have that so that I don't, it's what you can prove, right? Okay, just because you did something one time, that doesn't mean that you are always this forever, right? NACDL has this slogan. I have a shirt that says, we represent people, not crimes, right? Mm-hmm. So I think that's what it's about. Just because a person has this history or has done this before, that doesn't mean that you are forever that person, whoever did this. You are able to grow, right? That's what we're supposed to be about, redemption and this, just because you have this history, it's not all punishment, right? That's why we ask the question, are you a punishment or are you redemption? Yeah, that's what we do, right? So and that's how I feel about it. Like it presents more challenges, yes, I will say, but I don't think it's harder.
So Jackie, you asked us what was our favorite case. What was your favorite trial?
Well,
I have a favorite of yours, but it's not TV appropriate. What you said during closing.
this is, yeah. I say a lot of things during closing. So Eric and I tried a case in Fort Bend. It was a sexual assault of a child case. The child at the time of the allegation was 16 years old. Mm. She had a speech impediment, and in her speech impediment, it made it seem like she had some mental health issues. And so Eric actually did her cross-examination, and in the process of doing her cross-examination, he leans over to me and says, is there anything else that you think I should ask? And I lean back over and I say, ask her if she has any mental health issues, because part of the testimony had been for her to describe the genitalia of the client. And her description consisted of her saying, it was this big. And this wide.
I remember that.
Yeah, okay.
I mean, it would have killed her. She would just be dead. And so there was no way that we could just accept this testimony, but at the same time, I felt like the jury would probably think she just had a mental health issue. So Eric goes back into cross-examination and he says, I don't mean to offend, which means he's about to, right? But you talk a little differently. Do you have mental health issues? And she goes off. No, it's just a speech impediment. And it's like, so you don't have any mental health issues? And she like doubles down on not having mental health issues. It's just a speech impediment. There is nothing wrong with her brain. And so at that point, the jury goes out and they are gone for, I think, less than 15 minutes. I want to say roughly 10 minutes. And they said they went round table one time. They were all at not guilty. I think they spent the majority of their time trying to figure out who the foreman of the jury was going to be. And then they came back out and they delivered their verdict. And I don't know, there was just something really fun about that. But it also is one of those things you can't plan for, right? Like you are in real time getting this testimony from the stand and having to figure out how to deal with it. And it goes back to that pivot, right? Like we always have to be ready. You have to be listening enough to realize this doesn't make sense and I need to follow up on it and then pivot accordingly.
One of the jurors said that was the most important question for her, I remember. You remember that? I don't know if you remember that, but I remember one of the jurors coming out saying that question about mental health was so important because the stuff that was said couldn't be believable. I remember that. And I remember the client turning to me when she described that. He turned to me, he leaned over to me and said, "It's big, but it ain't that big." And I had a whole little laugh. Yeah.
So I don't know. Just you never know what you're going to get in trial, and that makes it very interesting.
That's true. I'll say, Jackie, your brother said, pause, chill, Jackie Carpenter. That's what he said, but it's just, I'm a little late on it, but that's what he said. I thought about something while you were talking. There was another case that I thought was one of my favorites. It was a DWI third. I had like a 72, 73-year-old client. It was a DWI third with drugs. They didn't have a DRE. He was 25 to life, but Susan Brown was the judge. And so she just really berated me. "Oh, you're not gonna take the deal. I've been in the courthouse for over 30 years. I've seen this happen. And so as a younger lawyer, just being in the office, I think I just came to the office at that time. I took the case over from a lawyer and, not a lot in the file. A lawyer might have thought it was a loser, but just being in the office, having us around and say, "What do you think about it?" "Well, I've done this evaluation. They don't have a DRE. I don't think this." And that support, you know what I'm saying? Because especially when you have a judge who's a judge and a retired judge and has this, and she's, "I've been in the courthouse 30 years, I'm telling you right now, he's gonna get 30, he's gonna get 40, the jury gonna do this, they're gonna see this and give him that." And saying, "We're ready for trial, judge." And then dismissing it on trial day, I think that was a big confidence builder for a younger lawyer like myself. And having the support of the office and other attorneys saying, "I mean, what do you think?" "Oh, she's saying this, but we're not worried about that. She's up there doing whatever, she's the judge, but what do you think? What has your evaluation yielded?" And then just standing behind it and then saying those results. So I think like that's big for younger lawyers, and a lot of younger lawyers that might not have the office. Just don't be intimidated by judges or anybody else who are telling you, "Hey, this is this, and he's had this history, he's got this, whatever."
Yeah.
Trust yourself, trust your instincts, and your investigation and evaluation of your own cases. I think it's huge.
Yeah, I think it's a lot of younger lawyers have fear, and you're right. The support that our office has really helps you overcome that fear. But a good message to younger lawyers is to fight cases and don't be intimidated and don't bow down. Because there's some judges that will try to push you to a point where you do cave in and you do sell out your client. Yeah. Just imagine, right? Here you had this case dismissed. It went from him catching a bunch of time to dismissal, which is like kind of incredible just from holding your ground.
Yeah.
So you talked about the support of the office. What sort of support does the Public Defender's Office provide?
A lot of support on many levels. So like I said, I went solo practice right out of law school. So I was on my own and, was doing well. I was comfortable. But you know, just running ragged. Everything was me. You call my office, I'm answering the phone. I'm doing everything was me. I'm the investigator, the lawyer, everything else. And I'm trying to collect the fees and get paid from people. So I think our office provides that. Every case that I have an investigator. Every case that I have, if I need an expert.
Who's your investigator?
My investigator is Ophelia Gomez.
Okay.
So I have an investigator on every case. If I need experts, I'm able to go to the office and those resources. I'm able to just pop my head out the office and, you know, a plethora of resources. Hey, what do you think about this? I know I can see certain lawyers say, I know you're good on sex cases. I know you do a lot of murders. I know I've got this child porn case. You've had success in these, whatever, and just talk to people and bounce ideas off. So I think that's great. And I mean, it's not just the office, it's just the culture. As a defense bar, I think we have a great culture in Houston as opposed to other cases. And like I said, I practice in several counties throughout the state, and I think Houston is a lot different. Like just today, I had a situation and I pulled Brendan Dunn out. I said, Brendan, let me talk to you. I got a question. You know, he's not in our office, but he was the closest person to me. I couldn't call somebody. I said, Brendan, let me ask you a question. I got this coming on, and we were able to solve the situation. So I think just Harris County as a whole is different than a lot of other places.
I agree. The Harris County Defense Bar is built different, and we help each other out. But I realize that people outside of the public defender's office don't necessarily know about the resources. But Mr. Davis, are there resources for people that are outside of our office that they can tap into despite the fact that they're not in the public defender's office?
There are. Not many people take advantage of it. And I guess, you know, one of the things I haven't done recently is publicize it. But we do allow lawyers to submit cases to our case review. If a lawyer wants to have a case review, they could always submit a case review and we'll bring them in. And just so for people that don't know, we have a case review process where we kind of like almost call it a brain trust, where all the lawyers in the trial bureau will come together, the lawyers that are available will come together on a certain day and we'll review people's cases. We'll hear them and we'll brainstorm the cases. And we get together and we give ideas about the defense. We point out issues associated with the case, and we kind of help each other on the case. A while back, we allowed lawyers from outside our office to submit cases to case review. And I used to send stuff to HCCLA's listserv, reminding people of it if they want to do that. I haven't done that in a while, because I haven't really been on a listserv as much as I probably need to be. But nevertheless, that's still something that's available. One is the case review. Second is, you know, you can always call appellate in our office. If you're in trial and you need information from an appellate lawyer, you can call. There's usually an appellate attorney that's on call, and you can talk to that person. Lawyers call me all the time and ask questions, those that know that they can. But if you have questions about a case or something associated with a defense, people will call and talk to me about it and ask me questions. It's usually the same lawyers that call me all the time. People call me for experts. They need an expert. They'll call and they'll email me and I'll send them an expert in the area that they're looking for. Because we have an expert database that we don't give out. We don't give our expert list out, but we'll give names off of our list as well to people given the situation.
So if I'm not a lawyer with the public defender's office, but I'm in trial and the state is about to call appellate, I can actually call the appellate division of the public defender's office? And
usually there's a lawyer that's on call that will help you, that can help you.
Yeah, I can't speak to that direct process, but I know when I started practicing, somebody gave me Bob Wyckoff's number and said, if you ever have a question in trial, you call Bob. And I did it. I didn't know Bob. He answered. He didn't know me from, you know, anybody from anybody, but he answered and he helped. So
absolutely,
I can speak to that for sure.
So if somebody's in trial and they have an issue, just call our office, and you know we'll try to direct you with somebody that can help you.
So for young attorneys, what do you think is the main thing that they should be learning?
Young lawyers in terms of?
Like they're inexperienced, but they're trying to figure out where to go from here.
Oh, I think of course, all the trial skills, right? As a young lawyer, one of the things that you want to focus on is all the trial skills. After that, I think you just really got to increase your knowledge of the law and your knowledge of procedure. And a way to do that is to read and to read cases. For example, you get hired on a case. Whatever the charge is, no matter how many times you defended that charge, pull out the statute, read the statute, read the annotations at the very beginning. Read the statute and the annotations. So get yourself a good book, good statute book. You know, the prosecutors make one and O'Connor's makes one. You can get either one of those that you want, and then read the statute and the cases that follow, because they give you an ideas for the defense. Case evaluation is real important. I think lawyers should do that. I would probably really spend a lot of time on pretrial investigation, figuring out how to investigate cases, how to analyze cases at the beginning if I were a young lawyer. I work on the trial skills, and I try to get in, sit second with somebody so I can see how the process of a trial worked. Get somebody you trust to sit second with them and watch the trial and work on trial skills, because one of the things that happens with most lawyers is that lawyers will pressure their clients based on their fear of trial. So if a lawyer is afraid of trial or afraid of the process of trial, doesn't know what to do in trial, a lawyer is more likely to press their clients into entering a plea. Right? And those lawyers are usually the lawyers that don't excel. They're usually the lawyers that don't go real far because they'll run from trials. And clients know it. They know when you're pressing them. And prosecutors certainly know it. They know who's a plea lawyer. They know who's going to fight. They know who isn't. And your offers will all be reflective of that. Whether or not you get a case dismissed is reflective of that. If they think you're going to go to trial, you're going to get it dismissed.
So we're in the last couple of minutes. Larry, can you tell us how you overcame fear in order to still represent a client?
Yeah, I think a lot of personal experiences kind of led to it, right? I had family that was incarcerated as a young person that I saw growing up that made me want to do this work. So I had those personal ties, and I think just mentorship. When I had an uncle who practiced in Jackson, Mississippi, who was an attorney, so I worked with him in the summers. And then when I went to law school, I linked up and had some mentors that I was able to work with, very fortunate, and all the way throughout. When I interned with the DA's office here, you know, I latched on to Tyrone Moncrief and probably didn't get an offer for a pre-commit because they said I spent too much time talking to defense attorneys when I was an intern at the DA's office. So I just, you know, did that, latched on to people. But I think for me, it's invest in yourself, right? I spent a lot of time, I spent a lot of money on my own when I was in private practice, investing in myself to go to these conferences and these trial colleges and these CLEs on my own. You have to, you know, because I was always told there's a 5 to 7 year learning curve, but what's the best way to catch up? You got to invest in yourself and put this money to try to catch up to the learning curve as fast as you are. For me, someone who went out private practice, that's the best way for me to, if there's a 5 to 7 year learning curve, I got to spend the money to try to catch up as best I can. And also with mentorship, I think mentorship is very important, but I think a lot of young lawyers don't understand that mentorship, the point of mentorship is to not need your mentor at some point. I think a lot of people latch on and say mentors, and they just want you to carry them or do this, but the point of a mentorship is for them to teach you some things and for you to also learn things, but you're not supposed to need that mentor at some point, you know?
We're in the last 30 seconds. I'm gonna give you the last word, Mr. Davis.
Thank you for having me. I appreciate you. It was great being here. I got to echo what Larry said. I think that is so important, right? It's getting a good mentor, getting somebody that you can learn from, somebody that can teach you. I learned from you a lot.
You're my mentor, Eric.
Yeah, but I still learn from you, right? So even if you're somebody that is a mentor, a mentee will teach you things. I mean, somebody that you're mentoring, you'll learn from trying to teach somebody some stuff, right? But in terms of myself, when I first started practicing, I'd ask people questions all the time. And there were some lawyers that would take time to answer my questions. And I think that's, for a young lawyer, don't be afraid to ask questions. Right. If you don't know something, find people that do and ask them those questions.
So we got to wrap up, but thank y'all for being here, and thank y'all for joining us.
Thank you.